As we come to conclude this interesting and indeed challenging conference on the Armenian genocide, from recognition to reparation, I would like to express my warm thanks and deep appreciation to judges, experts of international law, historians, specialists of genocide, and special guests for responding positively to our invitation and participating actively and responsibly in the discussions and deliberations of this conference. Dear friends, as experts in human rights, international law, and the Armenian genocide, you have analyzed and affirmed through your presentations and discussions that the demand of the Armenian people for reparation is valid in the context of the provisions of the United Nations conventions, international treaties, and international criminal law. You also referred to the limits and limitations, ambiguities and imperfections of international law, and identified a number of critical problems related to the application of international law in the context of geopolitical relations, which may hamper any process towards reparation. The conference, at the same time, opened new dimensions for further exploration and new avenues to move forward. We must be realistic. Neither we can continue anymore advocating only the recognition of the Armenian genocide, nor we can move forward smoothly towards a comprehensive reparation. We should avoid these extremes. What should we do? International law and its relevant international norms arising from treaties, conventions, and resolutions of UN General Assembly challenge impunity in all forms, spell out the international legal principles of accountability, justice, and rule of law, and affirm the necessity for reparation. Furthermore, the Universal Declaration of Human Rights clearly states that, quote, "No one shall be arbitrarily deprived of his property," unquote. And the return of property is an integral and essential part of reparation according to the Universal Declaration of Human Rights. Hence, the confiscation of properties is indeed a continuous crime against humanity, as we repeatedly pointed out. The international law provides the legal basis for the successors of the victims of genocide to present a collective claim for the return of properties to their rightful owners. Turkey may continue denying the Armenian genocide. It may continue spending significant political capital and issuing threats in an attempt to block initiatives aimed at recognition of the Armenian genocide. But Turkey cannot deny the very fact that about 1.5 million Armenians, Ottoman citizens, in 1915, with the pretext of relocation to avoid intercommunal clashes and for strategic reasons because of war, reasons given by the Turkish authorities, were forcefully driven out from their homes, leaving behind them thousands of churches, monasteries, schools, community centers, and private properties, and a huge amount of spiritual, cultural, intellectual, and financial wealth. It is important once again to remind ourselves of a few facts about the Armenian properties. A law signed by the Ottoman Turkish government on May 1915 states, I quote, that the land and properties belonging to Armenians who have been sent elsewhere as a result of the state of war and the extraordinary political situation will be immediately sealed by the Special Council and will be registered and taken under protection, unquote. The same law also assures that, I quote, the money received as a result of the sale will be preserved at the financial office in the name of the previous owner, unquote. In contrast to this law, and in order to give a permanent solution to the complex issue of properties, the Ottoman Turkish government invented the theory of so-called abandoned properties and put on sale and public auction the Armenian properties, even providing payment facilities to accelerate the sale. This act of the Ottoman Turkish government was indeed the continuation of the Armenian genocide. I repeat, the policy of denial does not exempt Turkey from its legal obligation towards the Armenian properties. Irrespective of the Turkish law of so-called abandoned properties, the Armenians have never given up their ownership. They remain the legal owners of their properties according to the international law, the Lausanne Agreement, which was signed by Turkey, as well as according to the Turkish domestic law. Therefore, within the context of reparation for the Armenian genocide, at this point in time, and as a first concrete step towards a full restoration of the legitimate rights of the Armenian people, church and community properties must be returned to their rightful owners. Here I have before me almost a complete list of churches and church properties which were duly registered by the Turkish state officers in 1912, before the genocide. The necessary documentation and information on these properties could be found in the archives of the Armenian Catholicosate of Cilicia, the Armenian Patriarchate of Jerusalem, the Armenian Patriarchate of Constantinople, as well as in the archives of the Turkish government. The Armenian Catholicosate of Cilicia, itself a victim of genocide, has the moral and legal obligation and the legitimate right to claim its own properties. I have before me a document of unique importance. This morning you already heard about the lawyer Zakaria Bezdikian, assistant on legal matters of the Catholicos of the time, who in 1921, upon the demands of the Catholicos, has prepared this list of the properties belonging to the Catholicosate, together with a memorandum. And this list was presented officially to the High Commissioner of France in Syria and Lebanon. This list contains all the necessary information about the properties of the Catholicosate. In the same memorandum, you can also find a well-documented assessment of the economic losses of Armenians because of the genocide. Therefore,